Hello and welcome to REDD's Business and Technology Podcast. My name's Jackson Barnes with my co-host Brad Ferris, and today we've got a little bit different of a guest. We've got Steven Hunwicks from HopgoodGanim. He works in the special counsel team around IP protecting and also technology. That should be quite interesting. First, Steven, did you want to? Thanks for joining us. And did you want to introduce yourself and background before we jump into HopgoodGanim?
Sure, thanks. Jackson, great to see you, and Brad, good to see you as well.
You too.
It's interesting interacting across the table in this way.
Yes.
Well, Jackson, thanks for the intro. I'm, as you say, a cybersecurity, privacy and technology lawyer with HopgoodGanim. We're a national firm in Brisbane. Our team's about 250 nationally because we're a full-service commercial law firm. We also have a really excellent family law team as well. I'm a Canadian-Australian. I don't know whether that makes me Can-Australian or Ausnadian.
I call myself a Canozzi.
Canozzi. I like it. And I guess before law, I had a career in technology, in software and telecommunications in Canada.
Mm-hmm.
And then, after that period of about 10 years, my wife and I said, it's time for some international living and work. And what better place than Brisbane, Australia?
Yeah, right. So you had your law degree already when you were over there working?
I didn't. Actually studied here.
Okay.
Yeah.
Yeah, right.
So I got to be house husband / full-time student for about 2 years while I did that. And after that 2 years, we loved the place so much that we stuck around.
Yeah.
We're about 16 or 17 now. So it's been brilliant.
Awesome. So HopgoodGanim, 250 employees nationally.
Mm-hmm.
What kind of law do they specialize in?
So it's all range of commercial law. And so we don't do criminal law, in effect. Yeah, commercial and family are the two sort of main areas. Our team is IP, technology, and cybersecurity. There are also there's a corporate team, a private enterprise team that looks after family-owned businesses rather than listed companies. And then all the accompanying sorts of practice areas, litigation and dispute resolution, estates and planning, environment, energy and resources.
Yeah, right, okay. So background and why you're joining us today, Rob Brown, who was from McGrath-Nicol, the director on last week's episode, actually referred you across and because you do some work in the cyber realm. Did you want to touch on where you fit in that? So when an organisation has a breach, for example, like what do you do within the cyber part of your position?
Sure, fantastic. Information privacy is a big theme. Cyber is a tangent on that as well. Where they start to cross over is data breaches, cyber incidents that turn into a compromise of personal information in some way. So unauthorized use, access, disclosure, loss of personal information. When an event like that happens, and you can think of it in the context of mailbox business email compromise or unpatched firewall produces a security vulnerability. Someone's in your network or in your mailbox. They have access to all of the information that's behind that gateway or that layer of protection that you previously had in place.
Yep.
And the question becomes, well, what did they get access to? And in the context of personal information, if they've had access to that information, there may be a need to notify the Information Commissioner in Australia and also the individuals whose information was included. You talked at a reasonable length with Rob about the Optus situation.
Yep.
A big data breach affecting a lot of Australians.
Probably the biggest, right?
No.
Oh, really?
The one affecting Canva, I think, a couple of years ago is by numbers bigger.
There you go. I didn't know that.
But probably the Optus one has the more immediate impact on everyday Australians, right? It's how many people have a mobile phone or an internet contract with them.
Yep.
And just the scale of it is enormous.
So you advise when there is a breach, say if an organisation gets someone into their email or into their servers or whatever, and then Rob, the forensic cyber team, actually does the contain what happened and go look at how it got in, that kind of thing.
Yep.
And you advise a business on how, when or if they need to tell people there's a breach. Do you want to go into detail on that, or what you generally advise organisations on when they need to tell and then how they tell?
Yeah, thanks for that. So a breach will come in and it might come to Rob first, or it may come to us first, and we generally get the other one involved because there are legal questions as well as cyber forensic questions about what are the technical parameters of the breach and what is the specific personal information involved. So we're going to be on a team, and that's together with the people involved in the business. The executive leadership team, whoever's handling communications, and whoever's on the IT side of the client. So it's really a team of 5 or 6 people, at least, by the time we get started. As you say, there are these legal questions of, did a breach occur? Well, there's a cyber incident. We know there is because that's why we're all talking. The question is whether that incident gives rise to this obligation to tell people. And there's legal threshold tests in there. So in the mandatory data breach notification scheme, if you suffer a data breach, you then have 30 days to assess and satisfy yourself whether there's a need to tell the information commissioner and the affected individuals. The test there is risk of serious harm. And that's the legal version of the test. It's really a case of, did the information and how it was compromised and the person who obtained it, do those contextual circumstances mean that there's a real risk to the individuals whose name appeared or documents appeared in that breach? And I'll give you some examples. If the information is limited to, for example, name, email, and phone number, then there may be an argument that the worst that can happen is a bunch of nuisance phone calls or spam, right? That's probably not a real risk of serious harm to an individual. On the other hand, in the Optus situation, we're talking about identity documents. Names, addresses, identity documents, dates of birth, all the kinds of information that might be helpful if somebody wanted to commit a financial crime or an identity crime in the name of that individual.
And that's obviously a much bigger risk.
Huge. Yeah.
So, and then you advise the business on what they need to do, and then you help them with essentially how they tell their clients or partners or whatever that they got breached.
Yeah, thanks, Jackson. Yes. So once we get a picture of the incident and what information was involved, then we can do that harm assessment to say, is there a real risk of serious harm? If there is, we can assist the business to notify the information commissioner. They have to file a statement. There's an online form to do that. The bigger piece is actually telling the individuals. You can imagine Optus is not having an easy time telling, up to 10 million people about that incident.
So are you seeing in this space, is there an uptick in the number of cases you're seeing? Like how's it trending, for lack of a better term, at the moment?
It's quite prevalent in the market. I don't have any numbers to suggest that it's on the rise numerically.
Yep.
But I think 2 things are happening, and this is just empirical observation.
Yep.
The breaches are getting they're somewhat more frequent, but more often they're hyper targeted. I don't mean they've gone after a business, but they've gone after a specific vulnerability that then gets access to particular information.
Yep.
And then it's a lot harder to detect.
So you're saying they're getting...
So the tools are getting better. The techniques used by threat actors are certainly improving.
They're getting more sophisticated because, like generally from what I've heard is there's like spray out attacks to everyone, but then there's like more direct attacks where they know you've got some information and they know where to go, for example, or who to go to. So you're seeing more sophisticated like threat actors lately?
More sophisticated threat actors, and when they're in the system, they're hiding themselves better. At least that's what the forensics are telling us.
Yeah. Okay.
It's also then becoming a bit more difficult to identify whether personal information was taken and what information was taken. So if the threat actor is hiding their tracks better, it's less obvious what information was accessed, exfiltrated, downloaded from the system. So then it's harder to figure out what that risk of serious harm is.
Yeah, which makes it quite hard, I'd imagine, for you when you're trying to advise on, what level of breach has happened and who you need to notify if you're not 100% aware of where they've gone exactly.
That's right.
Yeah. So I guess big part of your job is helping business owners or founders protect their IP, their intellectual property. Why is protecting IP important?
It's important because it's a valuable business asset. Everything that you've built up in that brand and the goodwill and reputation of your business is in effect the value. Especially in an information economy, it's the reputation of the business, it's how you do the work, it's the relationships that you have. That's a lot more valuable than the physical assets that are bought in the business.
Yeah, it makes sense because there's some recipes, like Colonel Sandler's recipe, for example, that would be quite important IP.
I'm thinking about the Coca-Cola recipe, the KFC spice recipe.
Yeah, that kind of stuff. It makes perfect sense. So, what are the ways legally to protect your IP?
The ones we like to focus on are the registrable forms of IP. There's a couple of unregistrable ones which we'll talk about, but actually, why don't we come to those first? Because you mentioned the Coke recipe and the Colonel Sanders recipe. Those are generally trade secrets. So things that you keep in the inner sanctum of the business and that you guard careful access to because you don't want to publish them to the world are these trade secrets. It's the confidential information, the detailed know-how of the secret sauce. How do you run your business and why do you do it so effectively? And often that's really difficult to write down. It's just kind of the vibe. It's the culture and reputation that you built. On the other hand, we've got intellectual property rights that are in registrable forms. These are things like trademarks, patents, designs, plant breeders' rights, real thing, seeds and whatnot. And these forms are registrable, but they require them to be written down and then put onto a public database. That's tremendously powerful because you can tell the world about this IP, declare your ownership over it, and understand that no one else has the right to then reuse that IP without your permission. The trade secrets, that's harder to protect. You've got to keep it, inside the closet, basically, and selectively tell people. If you're telling people there's confidentiality deeds and whatnot, non-disclosure agreements by another name that may limit how they can share your information without being in breach of that deed. But you have a lot more care and custodianship of those trade secrets and confidential information, whereas trademarks, patents, and designs can be put on the public register, advertised to the world, and your ownership is out there for everyone to see.
Right, so most people do that. Most people get their IP and put it on a public register, or is there a mix of some people do that and some people just keep it locked away under the bed at home?
Oh, it's totally a mix.
Okay, yeah.
The better way to protect and value that IP is to put it on the public register, because then it's searchable, it's tangible. You can actually you're telling the world that it's yours.
Yep. And not everyone would do that because I imagine there would be quite a cost involved in getting on the public register and doing it legally, more so than just keeping it yourself.
Well, just to put some real numbers on it, a trademark registration, once you get it, lasts for 10 years. It's renewable indefinitely for as long as you pay the fees. And if I spread the cost of what is a one-class trademark application, around numbers $150 a year. Not particularly expensive over 10 years.
No.
And meanwhile, that's attached to your business and you're able to sell it and transfer it with the business. If you decide to, you have an exit plan and move on, it goes with the business.
So that's, you would register it in Australia. Do you have to register in each jurisdiction?
Yeah, the misnomer is that there's an international trademark.
Yeah.
There isn't. There is an international registration, but you then have to nationalize it into each country into which it's protected.
Yeah, right.
So, usually you would start with an Australian registration, and then you would extend it to the world through the international system.
And that'd be much more costly, I'd imagine, doing it everywhere else.
It really varies by jurisdiction. Our New Zealand friends get a lighter hit on the wallet when they do it. It's much cheaper in New Zealand. And yet the US, China, and the EU are terribly expensive.
Yeah, okay. So REDD helps a lot of organizations help protect their data. But from what you see, what are the ways that you advise organizations or business owners to protect their IP with technology?
That's a great question. The technology isn't, I would say the technology isn't in the usual sorts of forms. It's not something you can buy off the shelf at, JB or through your technology service provider. It tends to be just using the tools to best advantage.
So we would advise organisations to have limited access to business owners, for example, or a trusted set of people in an organisation. Make sure it's backed up with a proper 3-2-1 backup policy, for example.
Yep.
Do you go into that detail when you're with an organisation around the actual data they have, like the electronic copy, for example, or do you push that back onto their IT partner?
We can provide tips at a couple of different levels. One is sort of that governance and framework level. And we can say, right, by policy and by practice, what are the general themes and approaches you should take? We generally steer away from choosing the technology for you. We think teams like yourselves are in a much better position to do that because you can see for the specific data for that particular client within their budget, how are they best able to achieve that technology and business goal? We can help with from a strategic perspective, from a governance and a compliance perspective, what are the steps you need to take? But we don't really tell you how to take those steps because they have to be right-sized for the business.
Yeah, right fit makes a bit of sense. Now, I've got an interesting scenario I wanted to run by you, and this is right up your field, being in a lawyer in the technology and cyberspace. Let's say, for example, there was an organisation that we were speaking to, and they were 1 year into a 3-year IT contract, but they were getting underserviced and overcharged for that. Have you advised organisations on how to break out of that contract?
Jackson, I can't believe it. That's a purely hypothetical situation that's never happened before. I have had occasion to see this kind of circumstance. If I can back up just for a second, I can say, look, if that client had their time again, hopefully they would get legal advice to start with, and we would help them to make sure that their contract with that technology service provider or MSP or really any IT service provider has a clear scope, it's on clear terms, it has a service level agreement, you understand what you get, what you pay, and there's a very clear mark to know when that service isn't being delivered. And if that wasn't the case, then there would be rights to end that agreement early. So, for example, for service level failures, if those were either missed on a month-to-month basis, maybe you're entitled to service credits, and maybe the contract would say that if those persist repeatedly for a series of years, a series of months, we often say 3 out of 6 months, then in addition to those service credits, you'd have a right to end the contract. Mm-hmm. So we try to put in place under those terms an arrangement where you're not just getting service credits or the right to complain about the service, but if it's a repeated, serious type of failure, then you get to end the contract as a customer. If that's not built in, and let's deal with that scenario, the next thing I would say is, as a customer, get your data before you start to stir up trouble. Unfortunately, some less scrupulous providers will effectively use your data as ransom, hold that over you, and keep you from leaving in that way. I wish I could say I hadn't seen that before, but it happens fairly regularly. So as a customer, make sure you've got the keys to your data and you start making you get those backups, for example, before. Because if things go terribly wrong, you're literally going to have to turn off the switch.
That's interesting because most business owners or people on a board responsible for technology, I'd say wouldn't have the keys to their data, and definitely not backups and copies and that kind of thing. And it's a shame that IT providers have to resort to that. So when you've come across that scenario before, you recommended to look at if they've, for example, failed the last 3 out of 6 SLA or service level response times. Then that's what you would look at. So you would look at the contract, look at that first, and then other ways to break out of it.
Yeah. So the first thing I'm looking at is the contract. What amounts to a breach or a non-compliance with the contract by the technology service provider? Just as a side note, I wish I could say that customers were infallible. They're generally not. So there's probably some contribution on either side of that table. But we're looking at the supplier's miss on the contract. So we'll look at the contract and say, well, what standard were they required to perform to? How close or not very close did they get to that standard? And the more we can build the story around what should have been done and which was not done, then we start to make the case for ending the contract early. But we have to do it in a way that still complies with the contract and with general contract law. You're trying to build the story of why should I be let out of my contract because of the supplier's failure to deliver the things they said, the promises that they made.
So if that provider is actually meeting SLAs in the contract and it's contracted, it's pretty hard to break out of from what your experience?
Well, I'd love to see a contract that has a right of what's called a termination for convenience. So the right to end the contract early for no reason at all, in effect, not for fault.
Yeah.
And sometimes that comes in after a minimum period of time. You might say, well, it's a 3-year, but after 18 months, you can leave early because the supplier has recouped its, upfront investment or something like that.
You did make an interesting point around, these kinds of arrangements are generally intended to be partnerships. You're working with each other on a day-to-day basis. And there is generally issues on both sides potentially. Yeah. Have you on the flip side, have you represented the supplier in a situation like that where maybe the customer is trying to get out and there's a bit of ownership on their side?
Yeah, there is usually a part to play on both sides.
Yeah.
Not everyone is the perfect angel that they claim to be. Yeah.
Yeah. And look, I guess from our experience, when we find that is when there probably hasn't been enough appropriate, given the nature of the service provided, it requires a level of engagement and insight and decision making, if you like, on the customer side. And that's probably where we find we have issues or difficulties, whether it just isn't that free-flowing communication or it's tough. You can't get access to the people you need to get access to make the right decisions, and therefore the service can suffer or can be detrimental.
Oh, 100%.
Yeah.
Inevitably, when we're talking about exiting a contract early, it's because of that first communication and then ultimately a relationship breakdown.
Yeah.
It sounds a bit like family. Well, it is. You work closely with a technology provider and a customer. You each rely on each other to do your best work. Mm-hmm. And when that stops, it hurts both sides.
Especially with an IT, whatever you call it, technology success partner or managed service provider, you're really partnering with that organization because you're giving them access to your data and them some responsibility for your data. So you're right, you have to have a very, intimate relationship with that. I've seen around some IT managed service providers, for example, meeting SLAs on response time, but not really meeting other things. They maybe not in the contract, but in the proposal around doing quarterly business reviews and monthly catch-ups and all like the service delivery and all of the other aspects of an IT contract.
Yep.
Have you ever advised or successfully or unsuccessfully, I guess, had a client who tried to break out because of those other reasons, not on the SLA agreement?
Comes down to the drafting of the contract and whether those ancillary support and service arrangements are really part of the what you get, what you pay. If they're value add, that's a more difficult argument than if those are line items on the contract, line items on the monthly invoice.
Yeah, right.
So it depends on what they are. The closer link you can draw to performance or non-performance, to the price you pay, there's a much better argument for that to be a breach of the contract, rather than just being a breach of a lesser promise, but not a fundamental breach of the contract.
Yep. So if it's core in their service offering and they're not delivering on it, then potentially, but not if it's a add-on for one additional little service. What advice would you have for organisations who are trying to select an IT partner, for example, change from their current or whatever, and they're looking at the different offerings or agreements? Also to your point, what advice would you give them to things to look out for based on? Imagine, I want to look up. You've done a bunch of work around understanding the GITC frameworks, and probably a lot of managed service agreements and that kind of thing. What would you suggest business owners would look for within a contract?
I think I'm looking for clues that we are talking about a partnership and a two-way relationship. It's not just I pay X, you give me Y. There is more a collaboration, and clues in the contract. When you read the agreement, or the service terms, or even the proposal, you'll start to see that. I know there's trouble coming when a proposal says words to the effect of, from the supplier's point of view, we will assist the customer to do something. That's difficult because, in my experience, the customer wants a solution. They don't want assistance with something; they want the solution, and they think that's what they're paying for. So we've encountered some suppliers who say, "Well, we provide a framework, a methodology, tools, whatever their offer is, but it assists the customer to do something." That to me is a time bomb waiting to happen. It happens in board governance software, for example. You buy a SaaS product that promises to help with board reporting, government governance, and decision making, and the vendor will say, "Well, I'm assisting the board to do something." That's probably going to break down when the tool doesn't perform exactly as expected, and the supplier says, "Well, I'm going to offer training and documentation to help you use my tool better." If we're resorting to that, something again has broken down in that relationship, and either the supplier hasn't understood the opportunity they're trying to solve, or the customer hasn't properly resourced that activity.
It's a good point around that expectation disconnect, and sometimes it is difficult to crystallize really the intent and the spirit of the agreement sometimes in contractual form, and find the balance between the cost of drafting a contract with all the bells and whistles and really captures the spirit with something boilerplate. So, and I guess that's where there's a bit of, it comes back to the relationship.
It does.
The spirit.
Yeah. The proposal is often a great start to that communication tool. The contract should just back that up. It shouldn't replace the proposal, the engagement, the communication, the relationship that you've built with your technology service provider.
That's good advice, because saying you're going to assist doing something is not saying you're going to do something or deliver something. So that is definitely good advice. And looking for the proposal worded around becoming your IT partner, which is something that we're big on.
One tool that you can adopt as a customer there is to say, well, to the supplier, if you've given me a proposal, then we, in most cases, want to attach that proposal to the contract, make it part of the contract, to say, well, that's what you promised. That's why we went into this agreement. That's actually part of the contract. Whereas some providers will take the other approach, which is to say, we negotiated up front, we gave you a proposal, you accepted it,
so
we'll put that in a drawer.
How does that work legally? Say there was contradictory terms, like do you have to, in the main contract, do you have to put a clause that kind of adds legal validity to the terms in the proposal? How does that mechanically work?
I think you've been down this street before, Brad.
Oh, well, we definitely, we do it, right? Like
it's true.
We will, but again, I'm not a lawyer, and I know what my intent is when we go into a contract, and to the best of my knowledge, what I read in the documents, I'm like, yes, I think this captures the spirit. But then there's always some scenario that comes up. You're like, oh, yeah, we probably haven't articulated that in the best way. Yeah. And our proposal is, we've done our best to not have contradictory terms, but it is evolving, and proposals go out. So yeah, just curious to how that.
100%. So yes, when we incorporate the proposal into the contract, we do it with legal wording that says, if there is an inconsistency between the general terms or a service module or something like that and the proposal, which of those will win and resolve that?
Okay.
To the extent there is an inconsistency. Yeah.
Okay.
So you put that drafting into the agreement. Yeah.
Okay.
That's some good advice.
In that process, a lawyer or other advisor can help be a third set of eyes on that package of documents that's going to describe the engagement. They can look at the proposal, look at the contract, and then in a way that is outside the provider or the customer's preconceived lenses of things they expect, take that analytical, objective, outside view and say, have you considered how this, how those service level agreements, whether the availability calculation in that actually reflects your business need? I'll just pick on that one example. Availability, whether it's by hours or by percentage, may mean nothing in the context of the customer's business. We do some legal work for a national retailer who, for all but 6 months of the year, isn't really that concerned about SLAs on the technology because it doesn't impact. But at Christmas time, they want 100% uptime. Any failure is $1 million loss to their business.
It's very material.
Yeah, right.
It's very much. So it's really contextual. A business that operates in one time zone, example on the east coast of Australia, has a different expectation than a business in Perth when we're talking about business hour availability.
That makes perfect sense. We do, I guess, managed service proposals and agreements all the time, and I would say it's pretty rare. Although one right now is actually seeking legal counsel on our agreement. Well, for whatever reason they need to, because they've got a lot of IP, funnily enough.
That's right.
Look, and they should, right? Like, it's just a diligence.
Yeah, well, that's what I was going to ask. Would you recommend that everyone over a certain dollar value engages legal counsel on a proposal around choosing a technology success partner?
Self-serving comment? Yes.
Yeah.
I did have a question around just rounding out the proposal and electronic signatures and electronic sign-offs.
Yeah.
I'm of an age that those weren't around when I was. Were they around when I was in school? I don't think so. So we have you click a button, it stamps your IP, you don't really sign it. And I do see some contracts that we need to sign and they want wet ink. So just the differentiation, the legal validity of, I'm sure it would be easy not easy, but definitely someone could say, oh, well, that's not my signature. But it's got their IP address, it's got their, the little type your signature in form. Like, have you come around instances of that where that's been challenged?
They're relatively few, and that's for a couple of reasons. There is legislation in each state and federally that say that in general, electronic signatures are as valid as the wet ink on ink on paper ones. And at least if we're talking about contracts signed and performed in Australia, no problem at all.
Okay.
That's not to say that they are valid 100% of the time. What you're looking for is intention to be bound by that contract.
Okay.
So if and it's very factually, significant at the time, but if you can demonstrate that the person who signed the contract, and we're putting air quotes around that, didn't actually intend to be bound by it, then there may be an argument that it's invalid. But I'm going to say that,
So 99% of the time,
exactly,
it's probably fine. Okay.
Yeah, cool. That's good. One other thing I want to bring up, I know I feel like we touch on cyber insurance every episode now, Brad, but
It's a hot topic.
one thing I heard a couple of weeks ago, which was, I guess, alarming from us as an IT provider for an organization, was that after an incident went down, for example, the actual company's legal team considering, I think might have even gone after the managed service provider in that organization, down to the level of, did they actually patch that firewall in time, for example, or was it behind on patches, trying to look for liability back onto the managed service provider? Obvious reasons. That's could be a problem for us, and it's quite a scary thing. And we recommend all of our clients get up to a minimum standard when it comes to cybersecurity, even if they are miles behind, for example, on the onboarding. We'd like to uplift them to a good standard. Have you seen any cases recently of that happening?
In court cases, no. That's most of those probably wouldn't get to court, but I can say I have seen that in real life. So there are, and this is played out in a couple of scenarios. One of them is we had to advise a client when they did suffer a vulnerability. It was a firewall patch that was missed. It was available on the vendor's website. So it was published in that way. There was a CVE number, that sort of thing. It was known to the world. It wasn't known to the customer, to our client, as the user of that firewall. And they hadn't ever received any email notifications from the vendor. So they weren't actually aware. If they had gone looking, they would have found it, and they probably would have applied it. But they didn't actually know the patch existed. The terms of their policy, when we looked at the policy, said that actual knowledge of a patch being available and not applied, and then basically willfully deciding not to apply it, could have voided their insurance.
Right.
Because they weren't aware and because they never had the chance to make that decision, the insurer still paid the claim. Whether that was, by grace or because they felt they were required to, they did pay it and it wasn't an issue. But I have seen that question come up to say, well, who bears the cost of the incident if there was an unpatched vulnerability in a firewall, for example?
Yeah, that's quite scary because, for organizations like we're at a decent size where we're pretty on top of that. But I imagine there'd be some smaller managed service providers out there with 2 staff, for example, or a one main guy and 2 offsiders. And that's quite hard to, if you're managing, 100 firewalls for organizations and there's patches coming out all the time, to actually keep on top of that.
So I was going to say the thing that I see in 98% of data incidents where an MSP is involved, and we can talk about quality of MSPs versus other providers later, but where I see the problem there arising is there was a lack of clarity between the MSP or the technology provider of any kind and the customer about who had responsibility for that maintenance and patching on the firewall. It was an open question as to who had that job.
So will there ever be imposed an assumed duty of care by the law in that regard, or is it kind of case by case and you work through a process to understand that?
I think in the short term it's going to be case by case,
and
most of it will come down to the form of the engagement and the terms of the contract.
Yeah, because it's really hard to cover for everything in an agreement. And again, it is one of those things where you can't be absolute.
Correct.
So you have to have process, you have to have controls, and those have to be reasonable in the context of the commercial reality of the situation. So, we talked about this with Rob last week. It is difficult when you're managing a risk and you can't be absolute, and you can't guarantee an outcome in that regard. You can only follow the right steps, the right procedures, the right process, have the best controls in place to try and mitigate the risk as best as possible.
Yeah. The conversation we have to our client is in effect, we've identified a risk here. We think it's this level of likelihood. If it happened, it could cost you this much. How much are you prepared to pay to reduce that risk?
Yeah.
Not to zero, but to something less.
Yeah.
And can you live with that? What's your appetite for that risk?
Exactly.
That's the constant dialogue and the trade-off that's being made.
Yeah, I guess it's always going to be evolving, and hopefully it doesn't evolve too far because, it is a scary kind of thing out there when we're responsible for people's data, but one missed firewall and come back and crush an IT provider completely. So hopefully it doesn't get to that extreme.
So for you guys, you're going to have processes and documentation to support the day-to-day work that you're doing. You're going to have policies about how you do your work internally. And then perhaps insurance on your business side.
Yep.
Whether that's general liability, professional indemnity, those kinds of insurances. But that's a fallback that just takes away the financial pain of the problem. It obviously can't help your relationship with that client if something has happened.
Yep. Yeah, definitely. That's for sure. All right, Stephen, conscious of the time, but I really appreciate you coming in. You've shared some really good insights for REDD as an organisation, and hopefully for some of our listeners around IP and how to break out of managed service providers contracts and things to look out for when selecting an IT partner. So really appreciate it. Anything else you wanted to add?
Thank you, Jackson. No, it's been great. I love this space because my day changes all the time. It's probably about 40 or 50% cybersecurity, 40% contracts, a bit more of IP and technology around it. The great part is working with clients to solve, their business, to meet their challenges and solve the opportunities they're looking to take on.
If one of our clients or listeners have these kind of problems and want advice, how can they reach you, Stephen?
Thanks. HopgoodGanim Lawyers website. I'm sure Google can help you with either HopgoodGanim, if we can spell it properly, or my name, indeed. And yeah, I think you guys will have my contact information. So
and we'll put it in the show notes.
Connect on LinkedIn.
For sure.
Awesome. Thanks,
All
Steve.
right.
Thank you both.
Again.
Great to chat.
Cheers. Thanks, guys.